Great. Okay, why don't we call the public hearing to order? This is a continuation of the public hearing with respect to the application for 40B permit on Elliott Street in the town of Milton. We opened this public hearing, believe it or not, in July of 2014. We've had several continuations: September 30th, November 6th, November 25th, December 16th, and January 15th was the most recent. We continued the public hearing until tonight. With the assistance of Mary Fitzgerald, we've kept throughout the process contents of the folder for the 131 Elliott Street project, which lists all of the materials that we've received from various sources throughout the course of the public hearings. And most recently, after the date of the last public hearing on January 15th, we've received two separate pieces of information. The first was on February 27, 2015, a letter from John Thompson, I think he's from the Department of Public Works, and then most recently a package that we received of updated plans and stormwater information, and that was on March 2nd, 2015. This list is part of the file for this application and is certainly available for anyone to inspect, but this constitutes sort of the body of written information, although we've had a fair amount of oral testimony at these public hearings, but this is the body of information, at least to this point, that would form the basis for any decision that the board might render. My name is Brian Hurley. I've acted as chairman throughout this process of the board. With me to my left, Mr. Ted Daber, to my right, Mr. Frank O'Brien, and we have throughout this process constituted the board. We did not close the public hearing at the last session. Subject to the thinking of my fellow members, it would be my hope and expectation that we would close the public hearing tonight. I don't have any particular agenda. We're certainly we'll welcome anyone that wants to offer any new information this evening before we close the public record, and we'd be delighted to give Kathleen O'Donnell, representing the Board of Selectmen from the town, and Peter Freeman and others an opportunity to speak before we close the public hearing. So I don't really have an agenda, so I'll let you guys take the con here.
Okay, thank you, Mr. Chairman. I can be brief, and I think the topic we want to address is the topic that we left at the end of the last hearing, which is really the main reason why the hearing was not closed last time, and that is the question of the new stormwater management plan and proposal. So the letter that you noted is an important letter, the letter from John Thompson dated February 27th, 2015, and that was responding to our submission of the plans that you also just referenced. So rather than me try to summarize, not being an engineer, I'll turn it over to Phil Cordero from Allen and Majors, and he can summarize basically what we have done since the last hearing and your meetings with Mr. Thompson.
Yeah, thank you very much. You know, at the last hearing, the way we left it for the continuation is that we didn't have a feasible stormwater connection alternative for the project at that time. We had some notions about some, but we hadn't fully vetted them out through the Department of Public Works, both the town engineer and the department director. Since that time, we had occasion to go out and perform additional field work, obtain additional records from the town, from the engineering department, and put forth on the plans dated February 20, 2015, a proposed connection directly from the site through the Central Ave Elliott Street intersection, discharging directly into Pine Tree Brook. And the correspondence that we received on February 27th from the town engineer was that they are amenable to this connection. We have a little more detailing to do with them as we move forward in this process. That's certainly noted. But that was to be expected anyways, given the time frame we were working under. And I think their letter stating that this is a feasible connection, I think is appropriate for the project, and continues to assert that we have appropriate stormwater management controls in place that can support this development. And I'm happy to go into further detail for any of the members if necessary.
Frank or Ted, do you have any questions?
No.
Kathleen, did you have anything you wanted to say
We
on
had
this
just
subject?
submitted the comments as we had asked the DPW in between plowing to take a look at the stormwater. And I've gotten a comprehensive letter, I think, from John Thompson, and which suggests a couple of conditions that the board might want to consider putting into the decision and with respect to applications and approved operations manuals.
Have you, over the course of the last week or so, or a couple of weeks, I guess, I've received, and I think John and Frank and Ted have received also various drafts of a possible decision, keeping in mind that we have not yet deliberated. I take it you've addressed those conditions from the Thompson letter and the most?
No, not the most recent.
Okay,
No.
okay, fair enough. Anything else to present, Peter?
No, that's really all we wanted to present. I was also going to comment on the proposed conditions in Mr. Thompson's letter, which we certainly find reasonable. We had already agreed that we would get the stormwater management permit from DPW. His additional condition is that we submit an operations and maintenance plan, which I presume would be reviewed by DPW to be approved, and that would certainly be appropriate, and we don't have any problem doing that. So we're satisfied with the letter, we're pleased with it, in fact, and now there is a known plan that we hope will be approved by you as well, subject obviously to the final plan approval and all the things we just talked about. So we don't have any further new information or further presentation, and certainly anticipating the close of the hearing, I will just tell you, I don't intend to give any great oratory about our position. I appreciate the very thorough and good review so far, and dealing with all the testimony and all of that. We do think, by way of perhaps oratory, but I think substance really, and just very briefly, we do believe that working through the board's questions and the peer review consultants that the board has retained, and all of the responses that we've made, that we really have taken to heart the issues and concerns that were raised, and we do believe that you have sufficient evidence and then some to find that we've satisfied any concerns that have been raised, and that this would be really a worthy project and add a lot of affordable rental units to the town. And with that, as I said, I will stop, not trying to produce rhetoric, but we do believe that we've met all of the standards of 40B, and that it's a project that you can certainly, in good conscience, with good appropriate conditions, as has been drafted. I won't get into the decision yet. You've seen that I've had some comments on the draft decision and some proposed revisions, which hopefully we can discuss. But, I would hope that you would feel as we do when you ultimately make a vote. Thank you.
Thank you, Mr. Freeman. Kathleen, is there any information you want to present, or any final thoughts or words that you would like to share with us?
No, I'm just going to be interested to see how this all works out.
Is there anyone here tonight that would like to offer any additional commentary or information to the board with respect to this application? Okay, there being none, I then would propose that we close the public hearing, and we can put that to a vote in a moment. Ted, do you have any thoughts on that?
I would agree. It sounds like there's no more evidence to be presented and no more questions, right?
I don't think there are, Frank.
I would think that after 7 public hearings and a pile of documents in front of me 6 inches thick, I would agree it's time to close the public portion of the meeting.
Well, then I would formally move then to close the public hearing with respect to this application. All in favor?
Aye.
Aye.
Aye. It's a unanimous vote, and at this point then the public hearing with respect to the application for 131 Elliott Street is officially closed. So at this point, under the open meeting law, we're required to deliberate openly and in public, and we will proceed to do so. So, without further ado, let me just, and I'm not going to engage in a lot of rhetoric either, Peter, this evening. I think I'm going to be fairly brief in my comments, and I look forward to hearing what Mr. O'Brien and Mr. Daber have to say. But I think that this has been a very good process. I think that the board has been very much educated throughout this process. I want to express my appreciation to many members of the public who have come here and spoken and raised legitimate concerns and issues in their process. I particularly want to thank representatives of the town of Milton, the fire chief, police chief, representatives of the Department of Public Works, representatives of the Conservation Commission, one or more town meeting members. We haven't heard from the selectmen, but I certainly know that one or more of the selectmen have been here at various public meetings, and I appreciate their interest in what has been, I think, an important application for the Board of Appeals to address. So I think the cooperation and participation of all quarters has been extremely helpful. I want to commend the applicant and all of the consultants that the applicant has brought forward before us. You have been helpful and very responsive to many of the questions that we have, some of which are informed, some of which are not. But you've been patient as we worked our way through some fairly complicated and difficult issues. I want to thank the lawyers, Peter Freeman, who representing the applicant, Kathleen O'Donnell, representing the Board of Selectmen of the town of Milton, who have brought, I think, valuable insight to the process. It's clear that this project meets all of the sort of jurisdictional requirements of 40B, both in the statute and the DHCD regulations. There's no question about those aspects. There's no question that Milton is nowhere near the 10% threshold with respect to affordable housing in the town, although I think that's a little bit misleading because I think Milton is nonetheless one of the most ethnically diverse towns around. It just doesn't happen to have DHCD qualifying affordable housing in many instances, perhaps where it could. But that's the situation that we find ourselves in. Obviously, there have been issues, legitimate issues raised with respect to this project. We've touched upon them in the past. I think probably the most significant of the issues that we've addressed over this 7 public hearing, 6 or 7 month public hearing have been the issues of traffic, issues of parking, issues involving fire safety, and most recently the issues involving the way to process and deal with stormwater runoff from the site. I think that we've come to understand those issues. I think that we've had good input from all sides with respect to those issues, and for the most part, I think we've reached the best accommodations and resolutions that we can, given the framework of the statute and the regulations. And so I appreciate those efforts. There is a parking issue in that area. It has always been my view that we can't foist that parking problem onto this project, though. To some extent, it's just an existing condition that we have to deal with in the best way that we can. The applicant has proposed a parking plan, which may not be perfect in all respects, but it's probably the best that can be done under the circumstances. And I think that we've addressed that issue to the point where it is no longer a issue of public safety that outweighs the regional housing needs. So on that issue, I think I'm satisfied that we're in a position where we not only can, but probably should issue a comprehensive permit. The issue of traffic is a similar issue. It's an existing condition. The police chief came in and offered some very helpful and what I thought was very honest testimony about the situation. He ultimately acknowledged that he wasn't really sure that the addition of a traffic light was necessary or appropriate, but it was certainly something that the town might want to consider at some point. All of the expert traffic testimony that we must rely on as presented to us seem to suggest that this particular project and its trip generation would not exacerbate existing conditions, and so I think we can make an informed conclusion and decision that that's not an issue that outweighs the regional housing need. With respect to the stormwater issue, I think we've reached an accommodation and resolution among professionals. I'm satisfied that that issue has been addressed, and to the extent that there are any lingering issues that relate to stormwater management and similar issues, I have great confidence that the Conservation Commission, as it goes through the process of issuing an order of conditions with respect to this project, will further address any lingering issues that may exist with respect to this project. The last issue, and it was one, I guess, that probably gave me the most pause because it sort of most directly implicates public safety issues, is the issue relating to fire safety. And the fire chief came in, explained his concerns. I think in part he acknowledged that it had a lot to do with sort of existing equipment in the town of Milton and how it might deal with a slightly different project than I think we're really accustomed to having in the town. But the fact that this building is fully sprinkled and that I was persuaded that there would be access, albeit maybe not optimal access, for fire trucks and firefighters to reach this building. At the end of the day, I at least was persuaded that that issue had been sufficiently addressed, and I pay particular attention in this regard to the Sunderland case that was decided by the Supreme Judicial Court a couple of years ago, that in a different context specifically addressed issues of fire safety as a foundation or basis for denying a comprehensive permit. So, having gone through those major issues and recognizing that there are many that would prefer some other use and development that's at this site, my inclination would be to vote to grant the comprehensive permit subject to conditions, many of which we've already had sort of presented to us in a very nice fashion in draft decisions, draft conditions that have been exchanged back and forth between Mr. Freeman and Ms. O'Donnell. So to sum it up, I think that the evidence that's been presented to us amply demonstrates that the regional housing need outweighs any particularized issues affecting the town of Milton. And so I will vote in favor of granting the requested comprehensive permit, subject to conditions that we might agree upon between members of the board. Mr. Daver?
Thank you, Mr. Chairman. I also would like to thank everyone for their participation and their wonderful input over these many months that we've had, and the quality of the testimony and the submissions has really been very helpful and very high quality, and to counsel and the consultants and the applicant and the members of the public who offered their comments and thoughts and concerns, also very helpful. And in thinking about this as we were approaching this date, it's very interesting that I basically had marked down the same 4 major issues that, maybe it's not interesting, maybe it's pretty obvious, but I marked down the same 4 issues that the chairman had, and also went through my notes and all the submissions as to how they had been addressed, and parking with the plan that had been submitted in November, and which I assume could be a condition to the to any permit that was granted, and to the engineer's letter with respect to the last stormwater management report submission, and also agree that my biggest concern was the one of fire safety, which was addressed, I think, over the course of a couple of hearings with the fire chief being present. And I had the same hesitation, and I also read the case that the chairman referred to, and was also swayed to a certain extent by the fact that the building will be fully sprinklered, and that there seemed to be, I think my memory of and my notes in the chief's testimony indicated that he wasn't clear that, again, the access was not optimal, but there wasn't any clear indication to me that it would be unsafe the way it was, or the way it's proposed. And so with all of that being said, and without repeating any more what the chairman has said, I think I would also be inclined to vote in favor of the permit. I'm not sure the extent to which we also deliberate on the conditions, but I guess you will enlighten me as to after Mr. O'Brien has his say.
Frank?
Thank you, Mr. Chairman. I want to thank the members of my fellow members of the board for being part of this process since the end of July. I also want to make mention that both the applicant and the town have been well represented, and council have been particularly helpful as we've gone through this particular process, this being the first 40B, major 40B project that the town and this board has had. I also want to thank the applicant's consultants for dealing with my sometimes uninformed questions, comments, etc., as well as the members of the various town boards, departments, etc., who were generously made available to the board through the Board of Selectmen and other parts of the town. Along with my fellow board members, for me, again, the issues came down, or my decision, my concerns came down to 4 factors: traffic, parking, Conservation Commission issues, and then fire safety. And I'll just address each one briefly in turn, because Chairman Hurley has done a very good job in addressing them as well. I think that the traffic consultants provided by the applicant, as well as the peer review provided by the town, was very useful. Whatever is built at this particular location is going to add to the traffic situation in the town. It is just a fact of life. But to borrow the words of my chairman, I think what I've been persuaded is that on the traffic side of things, with the testimony of the consultants, the police chief, etc., it is not a showstopper. While there may be traffic concerns and may well be increased traffic, I don't have public safety concerns relative to the traffic. In terms of the related issue of parking, I was strongly persuaded by the survey put in by the applicant showing similarly situated projects in the local area having, relatively speaking, commensurate parking. Parking will be an issue. Parking will have a number of conditions, I would think, in this particular decision. And parking may very well be an ongoing issue in this, for this project and for this neighborhood in general. In terms of the Conservation Commission issues, I now know more about stormwater than I ever knew, so maybe one of these years I'll go to engineering school. But at the end of the day, all of the stormwater issues, other environmental issues, indeed all of the Conservation Commission related issues are solvable. And I saw over a period of time professionals, engineers, etc., coming together and being able to come to professionally acceptable conclusions to what could have been some very thorny issues, and quite frankly, issues that were not entirely comprehensible to a layman. But I think that they were solved. At the end of the day, the one particular piece that stuck in my mind that really caused me to have a lot of thought about this particular project was the fire safety issue. I appreciate the comments made by the DPW, the fire chief, other town departments concerning that. I'm in the insurance business, and part of being in the insurance business is evaluating risk. And that is where, going back on my training, is what I did. I evaluated the risk. I'm persuaded, again, through the materials presented by the applicant's fire safety consultant and through the testimony of the fire chief, that a properly sprinklered, fully alarmed building is an acceptable risk. While there may be some access issues in certain portions of the building, after having read the Sutherland decision and after having seen the plans and everything else, I'm persuaded that the fire safety concerns, while legitimate, are not a stopper to this project either, given what the plans provide. So with that, Mr. Chairman, a somewhat long-winded summary, I would be prepared to approve this project subject to the conditions agreed to by the board.
Thank you, Mr. O'Brien and Mr. Daver. It's been a pleasure to join you and serve with you on the board for this hearing. So then I would propose to put to a formal vote then. All in favor of approving this 40B application with conditions to be discussed after this vote. All in favor of that approval with conditions, say aye.
Aye.
That's unanimous. Okay, I don't have any particular sort of knowledge or expertise as to what the next step here is, but I can tell you what I would like to propose that we do, and that is we've received some wonderful drafts. I looked at the most recent one this afternoon, and this was from Peter. It was from Monday, March 2nd, Mr. Freeman, that is, who had gone through Kathleen O'Donnell's most recent draft and then highlighted his edits in yellow on the draft. And I got these magically colored pages here with me tonight. What I would propose to do is that we go through the issues tonight that are raised by these competing drafts, and that we try to address those issues here and now. My memory is that we have 40 days to do a decision from the date we close the public hearing and vote. And so once we go through this process tonight and resolve what we can resolve, what I would propose to do is to take the most recent draft and do one, circulate it to the members of the board, and that we come back one more time for a public meeting, not a public hearing, and then vote on a final version of the decision. That's how I would like to do it, if that makes sense. Mr.
Sure,
Chairman.
that's certainly fine. I mean, there's a theoretical chance that you could agree entirely tonight, although you wouldn't have the final product, so
Right.
certainly,
The only caveat, the only hesitation I have on that, Peter, is that you might find it remarkable that I haven't read word for word every sentence in this draft decision before tonight. I just haven't had a chance to do
No,
that, and I'd like to do that.
That's fine. I would not
Unless
push
you guys want to sit here and watch me read it.
I would not push you at all, having, we appreciate that a vote's been taken, and, the cockeyed optimist in me, there's been some good back and forth on comments, and so that, I
There's been some
understand that,
great,
that's fine.
in my read of the most recent draft suggested to me that there weren't really all that many issues left.
No, I mean, I had sort of highlighted some I had the basic form, sent it to Peter. Peter sent me some comments, most of which I included, but I did highlight in yellow. So some of the yellow that you're looking at is my yellow.
Okay.
To sort of talk about where Peter had put in, council had put in some language, and we need to talk about that.
Why don't we do this? Why don't you take the lead on this for now?
Can we all make sure we're looking at the same? I
Right.
have like 3 drafts. Is this the one that was yesterday? March 2nd? or-
March 2nd?
March 2nd, yeah.
Okay.
Okay, the one, so we're all looking at the
This
same
one, I have copies here, but unfortunately, they didn't come out in color.
I have one extra in color if somebody
I have
would like
mine
it.
in color. This
I'm
is
good.
Mine's not in color.
I have the
but
March
it's
2nd
shaded.
draft.
Yeah,
Okay.
and so Peter forwarded a draft, and you can tell if you're looking at the right one, because on the second page, he has added a letter P to number 3.
Yes, I have that one.
So that's the last iteration.
So why don't you take us through where you see the issues are as we go through this draft, and we can talk about them.
Okay, so, the basic information that we had on the first couple of pages, that's just, you know, adding in some dates, adding in letter P, fixing the site visits and all the dates for the meetings and that sort of thing, which I'm sure that, we can sort of, that's just fixed. And then Peter had added, section 2 on the jurisdictional requirements and findings, and I didn't have any issue with that, so I incorporated it. I just showed it as blue as his
Okay.
language, which, is acceptable to me.
Does anyone, by the way, just to go back for a second, does anybody remember when the site, was there a site visit? Do you remember when it was?
I'm not actually
I
sure
don't
there was a
believe
site
there
visit.
was a
I
site
don't think there
visit,
was a
so
formal
that
site
should
visit.
be,
I don't think there was.
Needed.
I know I went to
remember
the
a
site
formal
with
one.
my 3 grandsons, but I didn't remember going with the rest of you guys.
No, I didn't go with those guys.
I didn't know, so I just put
Okay.
it in, so good,
All right.
okay.
We were all pretty familiar with the site.
I went there
so-
with my law school students, if you want to read that, but.
So we have to renumber those, but so let's
Yeah,
just take out that
that's
paragraph.
fine. And
All right.
then, yeah, so then we have to put in I have to put in all the dates of the public meetings and, or deliberated on the application and that sort of thing. So, then we have.
Kathleen, as you go through, it just might be, if you,
Yeah.
when you're flipping, just what page you're
Yeah.
going to, what section you're going
I'm
to.
just, I will, so I just had finished talking about section 2 on page 3.
That's
Which
jurisdictional
is the
requirements.
jurisdictional
right.
requirements and jurisdictional findings which council provided and I inserted. Number 3 is the findings. And those are the findings that we don't obviously have 10% of our housing available to low and moderate income families. We describe the project in number 2. With 3, we say that serviced by town water and sewer. We describe the location of the site, and then in number 5, we would have the option to say the project as conditioned above is or is not consistent with local needs, and your chair has said that he believes that it is, so
Right, and so we voted as a board.
that will
so-
is consistent.
Mr. Chairman, before we go out of that particular section, Roman numeral 3, findings, number 1, the percentage, 4.4%. Is that number in dispute, or am I mixing it up with one where there was some sort of calculation taking in the entire area of the town or something like that?
That's the one
It's a
and a
different
half.
calculation.
That's a different
That's a different
calculation.
Yeah,
calculation.
at H&W Apartments, there
Has
was
to do
of an appeal to DHCD on the basis not of the 10%, but on the acreage of the land devoted to affordable housing.
Okay, so this number, because of that, this number's correct.
This number is
Right.
correct.
Thank you.
Which is the issue du jour among 40B opponents.
Apparently.
It's now
So
in
I've
Newton
heard.
as well,
Yeah.
a few others.
That's why I asked.
And the 4.4% comes from DHCD information, so.
Yeah.
Okay.
And then the number 4 on page 4, Roman numeral 4, would be the actual vote.
Right.
Um,
So there it would just be grants.
grants.
Right.
And then the conditions start on the following page, number 5. I had a general question for the board as to how this project was going to be reviewed. In some situations, the site plans and the final architectural plans are submitted to the planning director. In some cases, they're submitted to the town engineer. I didn't know, sometimes it's the board. So I didn't
Do they ever go to the building
Building
commissioner,
commissioner?
or building
The building
inspector
commissioner,
too?
so- yeah.
Or
So-
maybe more than one?
Right.
Well, I think we have to have somebody in charge.
I think we have to ask, I just want to make sure, that's our kind of a question that comes through here a couple of times, as to who do we want, who's the sort of designated babysitter, essentially, for project compliance. This sometimes doesn't happen at all, but, you know, you do want to have somebody at town hall that's watching to make sure that, you know, things are supposed to be submitted before the building permit is issued, things are supposed to be submitted before the certificates of occupancy are issued.
So if this were not a 40B,
Well, how would you normally
proceeding.
do it?
that would be the question. Who would be?
It would be if this
Director,
wasn't a
yeah.
40B, it would be the building commissioner
Right, that's,
Okay.
Typically, I've never seen a decision, I've never written a decision that granted anyone other than the building commissioner oversight authority here. I mean,
That's
other
fine.
than
That would be fine
deferral
with
to other
me. Peter,
considerations.
is that all right with you?
Yes, yeah, we think that makes sense because he's, basically, there's combined building plans and zoning
Yep.
compliance,
So
and it's
we-
all based on what
so
your
we-
conditions
So-
are.
That would be, instead of the town engineer, would be the building commissioner.
Okay.
It describes the project as having no more than 57 units, 49 of which are 2 bedrooms, 8 shall be 3 bedrooms, 5 of the units are fully handicapped accessible, that's all from the applicant's application. 64 standard parking spaces, 4 compact spaces, 3 handicap spaces, and then the 65 underground spaces and the 6 surface spaces as shown on the plans. And then I had put in a number 4, that the applicant was going to have a parking permit system because you had expressed at one of the public hearings concerns about how that parking was going to be managed.
I'm sorry, this is under the conditions?
Yeah,
Yeah,
on page
okay.
5.
I mean, can we, there
Yeah,
were,
and
there were
these
like,
are-
yeah,
These
there
are
were,
not, I mean,
Right.
these are just my draft. You
Yeah.
folks can have all the authority in the world
With-
to throw some of this out, modify it.
and put the specific points of the parking plan in there. Yeah, okay.
As I said, I really provided this as a framework. This
Yeah.
is not.
That's
simple.
great, that's great.
In housing, we put in a provision, obviously, under the statute, 25% of the units have to be perpetual, have to be affordable. And the planning board chairman expressed the requirement that those units be reserved perpetually for affordable housing, not the sort of 20 or 30 years or whatever would be the usual financing. And then we had put in language, I had put in language to say that the applicant shall make sure that they're put on the subsidized housing inventory. The applicant's attorney would provide instead, as a comment, you can see that comment in the middle of the page, that they want to have language that said that they'll reasonably assist the town in qualifying the units, and we really wanted to put the burden on the applicant.
My comment on that is, and I think it's somewhat subtle, we have no problem assisting the town in doing all we can do, but to say that the applicant shall ensure that the units are qualified and placed on the SHI, it's beyond our control if DHCD says for some probably purely technical reason that could be solved, I grant you, but if DHCD says, sorry, something isn't right, it doesn't qualify, yes, my language would make sure that we work with you to do what we can, but to outright say, we ensure, that's beyond our control to ensure what DHC does. So that's why I thought that the spirit of my language absolutely is consistent with what Kathleen wants, but I'd be remiss on behalf of my client if I agreed to language that makes them responsible and theoretically in default of the permit for something they can't control.
I still want to say, get on the.
Well, I guess one of my questions, one of my questions
Yeah.
would be, if they weren't qualified, what would be the reason they wouldn't qualify? It would be because there would
Because
be
they hadn't been
something in
writing
the,
to the right people.
something in the submission that wasn't, or,
Or there was some issue about, how they ran the lottery, or how they got the affordable, the affordable tenants, something that wouldn't be in the control of the town. We're not the ones who are leasing these units. We're not doing the intake. We don't know who they, so if they don't count, the reason, it would seem to me, would be because there's some violation of the marketing plan or something like that.
Well, I think that can be bridged by using my language, but saying if the reason that they're not counted is because of some lack of compliance with the state requirements on the part of the applicant, then the applicant shall, post haste do what's necessary to comply.
Do towns
Yeah.
typically get involved in this, in qualifying units for SHI purposes?
Not usually unless it's a, local initiative program, where it's a town-sponsored project. Normally,
Well, I mean,
You know.
that's not quite true, because actually, even the process of getting them on the SHI is beyond our control. It's the towns that have to submit the request to DHCD to say, okay, we've now issued this comprehensive permit, and please add the units. And after 1 year, the way the regulations work on the SHI, as soon as the permit is granted, affirmatively as it is here, then the town would send that letter to DHCD. So first step is accomplished pretty much right away. If after 1 year, no building permit is issued, then the units fall off the inventory. And then we would certainly, if that's the case, we, God forbid, maybe it's because we're in appeals or who knows what. I don't mean with this board, but who knows what. So, you know, then there have to be future affirmative steps where we would still want to go through with getting our financing from the subsidizing agency, ultimately closing and pulling a building permit, and then once again, you know, the town would make the request to DHCD. So it's not that it's super complex, it's just that it really is beyond our control. So to cooperate and use reasonable efforts and make sure if we're out of compliance with something that we're duty-bound to quickly remedy, I'm fine with that language, but it just goes too far to say that will ensure.
So if we change that language to say that, you know, that the applicant shall reasonably assist the town with qualifying the units, but add in the caveat that you've suggested, that, you know, the applicant's gonna have to do everything it is required to do to make sure that those units.
That's fine,
Comply.
totally fine with that.
Right. Well, yeah,
I'd split that hair.
okay. I mean, I
Yeah.
thought I also heard him say that if it was something that had to do with the submittal or something, that the word shall was probably okay, if it was something that you could correct.
Yeah?
Yeah, I can't remember exactly how you phrased it, but.
If there's some compliance requirement on us that we haven't met, then we shall remedy whatever you want, you know, diligently or as soon as possible or within 30 days or whatever.
So Kathleen, can you do some language that you?
Yeah,
okay,
I've got-
that you
got
propose in a
something, yeah.
draft? Okay.
In number 6 was a clause, and this is really up to the town whether you wanted to include it, but lots of towns do, which is that you would like to have some preference to residents of the town. Obviously, those are somewhat limited by the fair housing requirements of DHCD, but it is not an unusual request to have some sort of ability to have some preference to residents that are defined as living in the town at the time of the application to rent, employees of businesses, town employees, households of children, you know, attending school in the town. You know, obviously, this is always going to be subject to the fair housing requirements, but, you know, to the extent that we could provide some kind of preference for town employees, town residents.
I mean, I personally see no reason not to do that, to give local preference to the extent we can.
No, I don't
Yep,
have a problem.
I agree.
And then what I highlighted in yellow is the language that Peter had suggested, where that, you know, we would have to provide, if DHCD, you know, they change the regulations all the time about this, but, you know, we need to provide some evidence as to the need for a local preference, which I think we could certainly do, given the housing costs in this town and the issues of providing affordable housing for town employees. I don't think that would be hard to do. So I didn't have a, this is, as I said, I just highlighted as suggested by the applicant, but I don't have a problem with
Okay? Then
including
I
that.
would suggest we incorporate it then.
In number 7.
Why it just
yeah.
reflects what DHC now
Yeah.
requires. I mean, frankly, in the past, it was almost more the applicant, ironically, but DHCD says, no, the town has to send us their data and whatever, so that's all.
Yeah. And so in page 6, on number 7, was talking about the permanent restriction and regulatory agreement. Language that's in blue is the language that Peter wanted to add, which I didn't have a problem adding. The language that's highlighted is the things that I needed to, the board should consider. And Peter perhaps would like to explain why he believes that we shouldn't include a provision restricting or limiting the dividend or profit of the applicant in our own agreement.
Sure. The first part of it is that the limited dividend requirements are under the Amesbury case, another SJC case, Amesbury Board of Appeals versus Housing Appeals Committee from, I think it was 2010, 2011, basically said that there are two, as a matter of law, areas which are completely within the domain of the subsidizing agency, not a zoning board. And those two areas relate to the affordable housing requirements and the profit limitation. And the court made very clear that those are exclusively under 40B, subject only to the subsidizing agency's rules and regulations and policies. The zoning board naturally is allowed, as you have done tonight and in the course of what we're doing now, addressing typical land use matters, all of those concerns under land use and development issues, but not the profit and not affordability. And that's the Amesbury case. And, you know, so the limited dividend requirement is up to the subsidizing agency, and they have a term of, candidly, I forget if it's 25 or 30 years with this Mass Housing Partnership Program, but it's either 25 or 30 years with a limited dividend requirement. And after that, although we have no objection to the permanent affordability, that's what the town regulatory agreement will cover, and I have no problem with that. In fact, you recall months ago, I shared with you a suggested draft of such a town regulatory agreement, which has been accepted by other towns for projects by my clients. So in a nutshell, that's it. You know, I just don't think there's any legal authority for a zoning board to enforce a profit limitation beyond what the subsidizing agency requires.
Kathleen?
Well, I mean, obviously, the most important consideration I have is that it's a perpetual restriction and that those units stay affordable beyond the financing period. I'm certainly familiar with the Amesbury case, and the fact that the regulatory agreement that they're going to have for their financing is going to have a profit limitation. My idea about a regulatory agreement that goes on after theirs expires would include the same kinds of provisions, which typically have those limits. So.
Well, I mean, you know, in that one, I can't agree to it. I've never seen it done beyond what the state requires. And, you know, in the long run, again, clearly the affordability and perpetuity of that is critical, and I respect that. And, you know, that this language absolutely provides that. You know, without getting philosophical, but I also think in the long run, it's, you know, the more incentive a developer has to, you know, to make profit, it's actually preferable for a municipality to have a project where, you know, they're going to put money in because they can get money back, and, you know, and yet it doesn't affect one iota the quality of the affordable housing that's going to be there. If anything, it improves it. So, you know, I think that your interests are well served by the way I have proposed it.
Mm-hmm.
My own view of this, for what it's worth, is that the town's concern is in keeping the affordable housing affordable beyond the term of the regulatory agreement. And I don't really see any reason why the town should be involved in attempting to limit the dividend or profit of the applicant. I would be inclined to go along with that addition from Peter. But
Or if we just took out the requirement of Roman numeral 3, and then he wouldn't need this last paragraph about the Board of Appeals of Amesbury, right?
Well, since it's there, I mean, I'd rather just address it
Okay.
head-on rather than say, okay, you know, we may have to come back to negotiate the agreement down the road. Let's just address it right now, would be my respectful request.
Okay.
But if you put number 3, little 3 in there, then do we need all of that verbiage about
Well, that's
the
what I was
measure
thinking.
decision? I don't see why we would. I don't even know what all that means.
If we took that out, then my proposal was to take out
I
number 3.
don't have a problem taking it out because the case is the case, and the important guts I'm satisfied with. I can tell you candidly that language actually was suggested by town attorney in a different town. That particular attorney added it to one of my original drafts, and so therefore I thought perhaps the town would like it. But if you'd rather take it out, that's fine.
Yeah, I'd
with
rather
me.
take it
Yeah,
out
I'd
because
like
I don't
to have
really,
that
I don't really
in
know what
there.
it means.
One of your former colleagues, Kathleen.
I'm sure.
Okay.
I
So
can probably
just-
guess who, too.
So can we go back? Is little 3 going to stay in?
No,
No.
No, I thought it is gonna, my
thought it
request is
was
that
gonna stay in.
Yeah, my request is that it does
Oh,
stay
yeah,
in.
that's right.
Yeah,
Sorry.
Little
three-
three stays
Yeah,
in.
Little three stays in.
and all the rest
And
goes
all the
out.
rest comes out.
Okay, that's fine with me. Is
You
that-
mean the rest of the yellow?
The
Oh,
yellow
so-
comes out,
Yeah.
right.
Yeah, okay.
I had that backwards, sorry about that.
Do we, Frank, you?
Yeah,
you
I'm
good with
okay.
that?
At the bottom of the page on architecture, it talks about the building, they're gonna conform to the architectural plans, they're supposed to submit final plans, and that would be to the building commissioner to determine that they comply with the plans that were submitted, to the board.
Right.
There was discussion about the mechanicals.
Kathleen, before we go,
Yep.
typically, in our decisions, we use the phrase substantial conformance,
Okay,
because we don't want to have a situation where there is some sort of technical change from an architectural point of view, and not have the building commissioner have the discretion to
Dismissive.
approve that. Moving a window or something. I
Yeah.
just don't want to have to, just some flexibility for the enforcement authority.
so in the
Chairman, are you okay with that?
Yes, yes. So we just say the building and the units in the building shall substantially conform to the...
Substantially conform.
Or did you want to end the second sentence where it
Where the
says the
plans-
applicant submits the final plans, whether the plans substantially conform to the architectural
That-
plans?
that's
That's
probably-
better.
that's probably
That's probably
better.
better.
Yeah.
That's probably better.
And then in 10, there was discussion about the mechanicals at one of the hearings, and the applicant has asked for a change to this language, which would say, to the maximum extent possible, the mechanicals wouldn't be visible to the homes abutting the site. And I don't remember what on the architectural plans was shown in the way of hiding the, HVAC systems.
I guess I'm
and
not
all
sure what difference that would make in terms of, because the maximum extent possible would mean that you could do things to make it so that it wasn't visible, So, I'm not sure that it,
Well, I know this is rehashing what was done previously, because I know it's not new testimony, but thank you for asking, and that's what I was whispering to Kurt, because it's his input. I wasn't trying to be coy here. I get concerned to say that, absolutely something will never be seen, and then if it is somehow, there's a violation. What you're suggesting is that it could be screened somehow, as opposed to simply, as the crow flies from the street, and that's, I hadn't even thought of that, and that's logical. Again, this is rehashing what was done, it's not new testimony, but, you guys, if it says, if you have to put up something on above the, on the roof, above the parapet or whatever, that
Well,
would block.
the units sit behind the parapet wall, and they sit back at the center part of the building. So from immediately adjacent to the building, you would probably never see them. However, there are other local streets that rise in elevation from,
But I've only said in this
There's-
language from the homes abutting the site.
okay,
So I'm not saying that
Yeah.
if you're flying over with a
Yeah.
drone, you're gonna
Right.
see them, but
I
for
mean,
the,
if you-
for the
yeah, that's
impact on those folks that are on the western end,
Okay,
is
Yep.
really what we're.
That should work, shouldn't it?
that should work.
Okay,
Okay,
let's
good.
just leave it that way.
On page 7, I know that there's an existing enforcement order related to the removal of the tree, I think. And so I just had put in the open space and landscaping that they were going to comply. I didn't really have a lot more details on that. And the applicant would like that clause deleted. The only other provision on the open space and landscaping is to the exterior lighting, and I had said that you wouldn't be able to see any glare. But the applicant would like to add, once again, to the maximum extent reasonably feasible, that glare wouldn't affect nearby property.
On the enforcement order, my thought is just very simple. I think it gets real messy if you have two tribunals, so to speak, that are somehow trying to enforce the same thing, and it's not a question of your domain, I don't mean that. It just doesn't seem practical. We're gonna be dealing with the Conservation Commission. The present enforcement order says something as we work through our NOI in order of conditions. We're hoping that there would be something that basically adjusts or changes the existing enforcement order, whether by a contribution or putting trees off-site or something like that. So to me, it's like, well, I sincerely don't think you have anything to worry about, because you know the Concom's gonna deal with it, and we have to deal with it. So it just seems not just redundant, but potentially difficult because of what could be ongoing. That's my, it's not trying to get out of an obligation, but we'll have plenty of accountability to the Concom, if you will.
I tend to agree.
I'm okay with that.
Yeah.
Okay.
Traffic, addressing the issues,
In paragraph 12, that language.
12, that to the maximum, sorry, I
Yeah,
should skip.
I think that's okay.
Okay.
Isn't that the most you can ever expect from somebody?
Yeah, I suppose.
Yeah.
In the traffic, when the police chief and the DPW director, we all talked about the traffic potential impacts, and we really weren't sure whether or not this was going to be sort of the tipping point for Central Street and that intersection. There had been some discussion about the applicant contributing an updated traffic study after the certificates of occupancy had been issued, so we now have some idea about what the actual usage and what the actual traffic patterns are once the building is occupied. So there had been some discussion at the hearings about whether we'd have the applicant contribute a sum of money towards a new traffic study once the building is occupied. So I had drafted the language that way, and the applicant has proposed instead that they would contribute $10,000 towards the installation of a traffic light if they did the traffic light within 3 years. But we weren't really looking, I don't think the chief was looking for money for the actual traffic light. I thought they were looking for the money for the study on whether the traffic light was necessary.
My memory of this is somewhat in the middle of what you've just said.
Yeah.
My memory was, and I have a pretty clear memory of this,
Mm-hmm.
that
I believe it was your suggestion.
the chief wasn't committing to even doing a traffic study, much less to doing a traffic signal. And that what we said is that, I know this was my intent. If the town decides that it wants to do a traffic study, then the applicant would contribute the $10,000. That was my understanding of how it would work, because it's very possible, and it would have to have some period of time in which to do that, because I
Yeah.
don't want to hold that $10,000 ad infinitum.
Right.
I had the strong impression from the chief that the traffic study might never happen, because I have a feeling that people don't really think that a traffic signal there is a good idea.
Yeah.
And apparently the warrants that we heard about didn't seem to suggest that it was necessary. So that was my intent, was to say, if the town decides they want to do a serious study of traffic signalization, then the applicant, within a period of time, I don't know, 3 years, whatever it might be, then the applicant would contribute $10,000 toward that study. That was my recollection of what we were
That's what I
talking
recall
about.
as well.
Yeah.
Is that how you recall it?
Yeah, and that
I
makes
think
more
so,
sense.
yeah.
I don't really want to have the $10,000 only there if we install a traffic light.
No, it
We're
was,
never gonna
my
do
idea, it was toward the study,
Right.
was my
Yeah,
understanding.
my memory is the same as yours as to the discussion. In terms of a draft, we thought that it would be better, naturally, for us to just pay it only if the light goes forward, but we're not gonna sit here and quibble with that, as long as the time period stays in.
Okay,
Okay,
I
that's-
don't
that's
have a
fine.
problem with the 3 years. So to do a traffic study. Okay. The fire safety, I don't know whether you want to expand that, but we had put in that the, circulation of vehicles, emergency access and signage will be consistent with site plans and conditions of this decision. I don't know whether, given the discussion that you've just had before you took the vote about the importance of the sprinkler system, I don't know whether we wanted to have some sort of further review of that sprinkler system or whatever, or a requirement that there's a sprinkler system included in the conditions of the permit. They're part of your plans anyway, right?
Part of building code requirement.
Yeah,
Yeah,
so,
my preference would be to leave that within the purview of the building commissioner,
mm,
as we would normally do for any other structure.
Right, and that's also, and from what you're saying, I gather you're not objecting to what I struck, which
No.
is, right, because again, it's all controlled by
Right.
the,
Yeah.
in fact, you folks mentioned that Sunderland case, and that shows pretty clearly what the building commissioner, together with the fire chief, would do. So, yeah, if that's struck, that's fine.
Yep.
That's fine.
Talking about the
Yeah.
wind out language, yeah.
In the stormwater, Peter had suggested crossing out the first sentence, which is of course true, because that was, when I drafted this, we didn't have any
Right.
updates. So prior to the issuance of the building permit, the applicant has to submit a revised stormwater report to the DPW. They could get Horsley and Witten to take a look at it at the applicant's cost and expense. No building permit would issue until the applicant has obtained the approval of either the Concom or DEP under the State Wetlands Protection Act for drainage into Pine Tree Brook, because they're gonna have to have that. Given the letter that just came in from the DPW, I would propose to add the conditions suggested in that February 27 letter about their application for a new drain and excavation in the right-of-way permit that needs to be filed, and the submission of a operations and maintenance plan.
That would be all right with
Yeah,
me.
sure.
Is that okay?
Yeah, absolutely, that's fine.
In number 16, it was on page 8, is really the discussion about the sort of environmental conditions in the site. There's been lots of material provided by all kinds of people on the history of this plant, of the buildings, the underground storage tank. I think there are monitoring wells that probably haven't been monitored in a considerable period of time. So it was my proposal that within 60 days of the decision being recorded, that the applicant would engage the services of an LSP to do a new 21E report, because it's been some time, probably more than 10 years, since anybody's looked at anything in that site. And then I wanted it would seem to me, reflecting all the comments that had been made by various and sundry town officials and board members, that you wouldn't get a building permit until that 21E report, and a clean 21E report had been provided. The applicant's attorney wants to wait until they get an order of conditions for the project, or a superseding order from the Concom, and I don't know how long that would take. And as I said, there's been some real concern about what's going on in that building that people have talked about at all of these meetings. So that's really a board decision as to the timing about when an LSP is going to be there. And then the applicant's attorney has suggested either it's clean or they removed and mitigated, everything that they needed to remove, and I don't have a problem with that. But I do think there's an issue about the timing.
Can I ask you a question?
Huh?
Mr. Freeman?
Sure, thank you. Oh,
No, I was going to ask you a question, but
Well,
that's
go ahead.
okay. Go ahead. Go ahead.
Sorry
You
about
have
that.
something to say.
No, I was just going to say, again, we're not suggesting strike the provision. It is a question of timing, and my thinking is the same as a little bit what I said before about the enforcement order. We're going to be dealing with this with whatever order of conditions is issued for probably right at the demo, as well as the project order of conditions as well. And it just seems a little cumbersome to have a certain time frame that may not mesh with what the Concom is going to do. And there's also some factual reasons why it doesn't necessarily make pragmatic sense to do it necessarily right away, meaning not in conjunction with the demolition, because there's no known or perceived contamination right now. It's true that it hasn't been monitored, but that's because it's under the control of DEP, and there's been no requirement to open up the wells and monitor. There's also the fact
Peter,
that...
I don't even think that's true. I mean, I don't think they've complied with the orders from DEP.
Well, we submitted, and there's been no contrary testimony, we submitted the status reports from DEP, and it attained that result, which until anything further happens with the building, is basically fine. I'm not saying that there hypothetically couldn't be something, but, I think it's not a question of our trying to avoid responsibility. My whole point is it needs to be in conjunction with what's going to happen with the demolition of the building as approved, we presume ultimately by the Conservation Commission. And then the other point, though, is there's some cross-interaction between the town building, you know, those tanks. I think originally the oil that came out was from the town portion. The tanks that are, correct me if I'm wrong, but the tanks are located where again?
And the open parking lot on the corner of Central and Elliott.
Yeah, but
So
in terms of,
the tanks are near, they'd be to the south of the town parcel. And there's a waste oil tank and a fuel oil tank, and they service the building as a whole.
right, so there were,
There's questions there that need to be squared away, but to correct Kathleen, there was an oil spill there in 96 and 97. That's the Rizzo Associates report that's been circulated by the town planner and one of the Conservation Commission members. A permanent solution was found for that spill. The fill was taken out of that lower machine room, it's clean, and what they have is what's called an A2 finding. And the only reason they couldn't get background is because the structure is there. And what we're saying is we want to remove the structure, then go in and lift the tanks, and then get an A1 rating, because we'll be able to test around where that cleanup was originally in the lower machine room. So it just makes sense, it's practical, to do this in conjunction with an order of conditions from Concom.
and lifting the tanks is part of it, because that, should there be any issue, you know, it can't be cleaned up until, you know, those tanks are gone. So that's the real proof of the pudding, so to speak. So again, we're not trying to avoid any responsibility, far from it. It is purely a timing issue related to these practical concerns, because when they demo, part of it will be removing those tanks, which, you know, God willing, they'll be secure, and there's nothing there right now in terms of, you know, leakage. But if there is, we have to clean it up under the DEP rules, and then the protocol has to be properly implemented in removal of those tanks, which is under state regs and all, but also really, I believe, inspected and supervised and all that by your fire department. You know, so there's hands-on control, and that's how it'll be done properly. So, again, I don't want to belabor it, but I just, you know, it makes more sense to just not have it here, but simply, whenever it's required under the 21E laws, DEP, and then the order of conditions.
And also, our funding agency, Mass Housing Partnership, requires a 21E report on any loan over $500,000.
Yeah, good point. There'll be a brand-new 21.
We have to do.
I'm not understanding what you're saying.
At what point?
So you're going to get an order of conditions at some point. And what do you have in mind to do at that point? You're going to go in and pull out the tanks after you get the order of conditions?
Well, yeah, the first order of conditions would be for the demolition. So
Okay.
yes, as part of the demolition, they would, you know, pull out the tanks. They would see whether there's any
And
contamination.
then after you finish the demolition, you'd be ready to file for your building permit.
Right.
And at that point, you would do the 21E?
Well, I think the 21E would probably be done before, because the funding for demo and all that presumably is from the lender. But,
I don't understand the
Getting
problem. then.
confused.
well, Steve.
That's not exactly.
Okay.
It depends on how it plays out with Concom, with demolition, and with the order of conditions for this permit. And what I'm saying, my position is that I want to roll the financing of, if there is any cleanup to be done on that site, I want to roll that financing in to the project, the construction of the new building. The demolition is the reason that the applications are separate is because I have an agreement with the town of Milton as a result of a 139 hearing that would move forward with the demolition of the site. So that's why they had to be split out. The timing of this just happens that nothing has happened since then, but this has been an ongoing thing for over a year as well. So they're starting to overlap, but they are separate issues. I may only get a demo order of conditions first from Concom. I don't know how long it's gonna take to get an order of conditions for this permit. So that's why we wanna have this separate from this condition, because I don't know timing-wise how it's gonna flush out. There's nobody avoiding the tank, avoiding tanks or avoiding any issues down there. As of right now, the documentation that we have, we don't have a problem down there. And I certainly don't wanna go looking for a problem.
But in any event, you're going to do a 21E report. It's
Yes,
just a question-
absolutely.
It's just a question of when.
Yes.
And I think you should be doing it with for the demolition, not waiting until you're doing your site development. I
Well,
mean, you need to know, we don't even know whether there's other stuff there. The monitoring wells haven't been checked for forever, the building's falling down, you know, I mean, who knows what's going on there? I think it's, you know, from, as I said, from our perspective, the earlier that there's a licensed professional looking at that project, the better. And waiting until you've demolished it to get an LSP out there, I think is risky.
What's the risk, Kathleen? I'm not sure.
Well,
I
who knows
understand.
what, you know, how much worse the situation could get, what they do with the demolition. You know, you need to have somebody monitoring the demolition to make sure that you're not making the situation worse. You're right next to the river. We already know there's some little pipe that apparently goes underneath the rail line and into the Neponset without anything protecting it. So, it seems to me that there needs to be some better protection done for the demolition than there would be for even for the construction.
No, we had all hazardous materials removed from that building, and the Conservation Commission has the documentation of the removal and the disposal sites where the stuff was shipped to. There's nothing in that building. The question with Conservation right now is they have a question about the oil tank, the waste oil tank and the fuel oil tank that's out in the open parking lot, and it's 10 feet below the ground. What we're talking about for the demolition is to relieve the safety hazard that the town has cited. That's what that demo is all about. Otherwise, it would all be in the one site plan application. So, and the thing is, the town has a collapsed building down there. I don't. Town has the collapsed building. So we have to act on this, the town has to act on this. They've damaged our building down there. There's a safety hazard there, according to the building commission. So, you know, we have to move on this. And what they want to do is talk about oil tanks that are in the ground. What I've already stated at the Conservation Commission, that before we do any construction, I'll open those tanks and make sure they're empty. Just to make sure, so that no matter what happens down on that site, there won't be a problem. So the oil tanks have nothing to do with demolition of that site. And to say that there's something going on in there, the site's been vacant since the late 80s. There's nothing going on in that site. And there hasn't been. And there's no requirement for us to be monitoring those wells anyway. That's a closed case, permanent solution found. As far as I know, you can't get a better solution. And depending on the use, residential use requires the highest level of cleanup for a site. And we're just getting to a point where I'm gonna have a use. So I wanna be afforded an opportunity to get my ducks in a row, have a good game plan down there and knock this job out. And that's just putting the cart before the horse here. That's all that's going on.
Let me just go back and understand this again, because maybe it's just late in the day and it's been a long day. So you're gonna go in there, you're gonna knock the building down.
Right,
Then you wanna pull the tanks.
right.
And after you've completed those two missions, and before you get your building permit, you're gonna do a 21E report of the site at that point to see what's there.
The 21E will probably be done,
Well, I think,
will be
Steve,
done after the demolition, but before the tanks are pulled. I'll have an LSP on board, because you need one to be pulling tanks out anyway. You have to have.
Why don't we just say that in here? Doesn't that solve the problem?
yeah, that's fine. Again,
Just change it from building permit to after the tanks are, after the demolition of the building, but before the removal of tanks, the 21E report will be done. Seems to me it'd be a good
Okay.
compromise.
Can I ask a question?
Sure.
I mean, that's not going to get us into any inconsistent timing with the Conservation Commission, is it? Because I do remember Mr. Kiernan being in here and expressing concern about 21E and everything. And I mean, are they going to impose that as some kind of a condition? And is our timing apt to be different from what they might come up with in terms of?
It could be. That was my initial reason, as I think I said a few minutes ago. Maybe I was inarticulate. It happens. But yeah, that was my initial concern, is possible inconsistency. But that said, I think the compromise proposed by Mr. Hurley is reasonable. If there is an inconsistency, we can tell the Concom what you guys want. If they say something else, if we needed to come back to you, we'd tell you, and, you know, I mean, it would be worked out, I think, between the two boards. So,
Well, I mean, could we say in there, provided, however, that if the Concom wants a different date, that the Concom will control? I think it's unlikely that the Concom is going to want a different date, but I mean, I don't want to.
So,
I don't want to come back here and have a
Do a modification.
sit down of who's right about the date.
Right.
As much as I like you guys, I really want to be done with
Yeah, I was
this
just gonna
one,
say, you
yeah.
mean, you don't.
Sign that decision.
No,
I
that's fine, although
resigned
not,
from the board at that
not-
point, so.
you know, same thing, you know, Concom/DEP. I mean, hopefully, we're not in appeals, but, you know, is the,
Well, you have that in here anyway.
no, that's, I mean, that's in another section, but, you
Right,
know.
but,
So
so if we
couldn't
futz,
it,
if
couldn't
we,
it, couldn't it say after demolition, before removal, unless the Concom specifies a
Right.
different date?
Yeah, Concom or
Or
superseding order, yeah. That's
Okay.
fine, that's fine.
Does that work for you for a construction perspective, Mr. Herman?
I'd rather, if we're gonna keep this language, I'd rather not refer to Concom, as long as this language affords me the opportunity to take the building down first, then tackle the tanks. Then whatever happens with, we're gonna have to wrestle that out with Concom, because some members are of a different mind on that board. I'm not comfortable with,
Mr. Freeman, you want to consult with your client for a minute? I should have asked you instead of your client, I apologize.
Oh, that's okay. Tell you what, yes, I should, but maybe we should just go through everything else.
All right, let's go through everything else.
Let's go through everything else and
Yeah.
we'll come back to it, because, yeah,
It seems
thanks.
like it should be a soluble
I agree.
problem.
okay. Infrastructure, you know, was repeating, you know, which, that the town isn't gonna be responsible for their stormwater management system, their driveways, their parking areas, snow plowing, all their connections, the lighting, trash disposal, recycling is all gonna be handled by them. Site utilities are all gonna be, you know,
Mhm.
handled by them. Then was the question about the, in 18, I'd put, if the town determines that it was necessary to hire consultants to review building plans, the applicant would like to have that be the board determines that it's necessary to hire consultants. I didn't think that you really, as you just said, that you really wanted to have continued involvement.
I don't, and I don't feel like well, I
Yeah.
speak for myself, I don't think we have the expertise to be reviewing the kinds of plans that are listed here. It makes no
No.
sense to me that we would do that. So I'd like it to be the town.
Yeah, I don't have a problem with that, other than the town is just too kind of amorphous, are we gonna have, or
So
multiple
do you wanna have the
headed,
building
You wanna have
commissioner?
the
Yeah,
building
the building
All right,
commissioner
Building
is fine.
commissioner,
That's fine.
let's make that consistent throughout.
Yep, that's fine. And then he wanted to make reasonable costs, and
I
that's
think
fine.
it always should be reasonable.
Yeah. The, right,
Always.
exactly.
I mean, page number 9 looks.
On page 9, the only the only issues on that was to make sure it was the town engineer that was reviewing, but I think we're all gonna make that consistent with the building commissioner.
Right,
And it's gonna be the building commissioner all the time. And that reasonable consultant fees, that's fine. Construction is on the bottom of 9 and continues on to the next page, and I didn't know on 10, what your time periods were gonna be for,
Just the
the
hours of
construction
construction.
on this site. I didn't know what you normally put in your decisions.
we've never done a 40B decision that I know of, so.
Well, any kind of large construction, well, we don't really have
Mm-hmm. really
big
have any.
constructions here, but,
We tend to leave that to the discretion of the building commissioner.
Right,
okay,
We invest substantial authority in the building commissioner so as to give the town flexibility in terms of the enforcement, while at the same time allowing the builder, the developer, the type of flexibility that they
Yeah,
need
you
in
okay
order to
with
get the
that? Yeah,
building done.
That's fine.
Okay.
Yeah, that's-
No,
okay.
no, we just have normal
No.
ordinance.
Yeah, I mean, as I said, some towns do, you know, have provisions for that, so. And then, in 24, there was just a question about, there'd been some discussion about removal of ledge and excavation. Applicant's attorney wants to add in 24, if there's removal of ledge, if any, and the approximate number of necessary truck trips, and I don't have a problem with either one of those
Okay.
changes. In 25, I had a provision in here that said the construction was supposed to be completed within a year. And the applicant would like that deleted.
Why- why?
There's a practical and a legal. The practical is, I think it'll really chill my chances of getting a construction loan, because a lender's gonna say, well, you know, I mean, there's all kinds of reasons why it may not be completed with a year, and what the heck are we gonna do? Suddenly you're out of compliance, and they suddenly, this board, you reasonable folks may not be here, and we don't get an extension. I mean, and I'm serious. I mean, I'm in the middle of writing several zoning opinions. They rely on me. And it really is a non-starter with a lender to say, well, it doesn't even, it doesn't even have an acts of God or, force majeure clause in here. And obviously, we don't want to make it into a lengthy construction or insurance contract. So that's a practical reason. And it's very seldom that they're ever done. And the reason that they're seldom ever put in is there are specific lapse provisions in the regulations. And of course, I just happen to have it here, 56.0511. 10C, the lapse, it's very clear. The only lapse provision for 40B is if you don't start construction within 3 years of the grant of the permit. And once you start construction, you're subject to normal case law and building protocol. You get a building permit, you start within 3 years. If, theoretically, if you start and stop and don't come back for 4 more years, might the building permit be invalidated, and might the permit at that point have lapsed? Possibly, but that's a different situation. And the other thing is, even within the lapse provisions and the provisions in another section of the CMR for 40B, extensions of a comprehensive permit are to be liberally granted. The regulation basically says that it's typically to be, if an applicant requests an extension, excuse me, on a permit, then the regulations themselves say they're to typically be treated as an insubstantial change, and typically that means that they're to be granted unless there's some extreme, change in circumstances in the area that would somehow create a harm to the town. So, it's virtually impossible to enforce anyway. The 3 years, not starting, that's different. We don't start within 3 years. If we didn't get an extension, shame on us, it lapses. But this, is just not right from a borrower's perspective, and it doesn't really add anything.
What if we just left the first sentence in? That's more hortatory than,
Well, I mean, it's better, but a lender's gonna still say, well, it must be in there for some reason.
Well, it's because we want this, project moving along.
Well, I understand, but,
Something like 18 months, would that help, or?
I mean, from a pragmatic viewpoint, you do know, as opposed to, and I say this in all seriousness, because again, I understand, I respect where you're coming from, even though I do disagree, but, it's not a project that's gonna be phased. I mean, once it starts, this building is presumably gonna be built, so on the one hand, you might say, then why are you worried? On the other hand, I say, well, I have to worry, but, with a project where you could build the first street and first 10 or 15 units in a subdivision, or even a cluster, and then maybe the rest of it is left hanging, which could be a concern and liability for the town, that's not gonna happen here. I mean, they have to build it all at once. It's not a phased project. So, overall, I think it just really creates problems for us and doesn't really add anything to the town.
all right, why don't we come back to that?
In 26, the applicant wants to add to the maximum extent feasible, no erosion would occur off-site, and then he wanted to cross out the plans showing the catch basins and the site perimeter controls, and the applicant made the comment that, most of that's gonna be covered by the stormwater management permit and by the order of conditions, and I agree with that. I don't have a problem with taking that out of this particular
Okay,
clause.
good.
And the 27, I mean, this is gonna be tricky anyway, because they've got whenever the Mattapan line is starting to run again, that's gonna be right there, and the river's right there, so the applicant has suggested some changes to that 27, and that they're gonna use their best efforts, but I actually liked my language better, which was that if there was any issue at all, they were gonna stop and cease and desist until they had done the remedial work. I don't think best efforts to remedy the situation really work, given this location, but I leave that to you folks to decide.
Probably at least a two-part response. One is, the reason I inserted best efforts is it says within 1 business day of notification. And, you could be bending over backwards to comply and all of that, but you may not be able to, mobilize whatever piece of equipment needs to be there within one day. I mean, this is a quick example that's perfectly possible. So, you know, again, I didn't propose to strike within one business day. That's why I feel the need to say, use best efforts. And again, cease and desist. I mean, you know, theoretically, if, you know, like a kid's little bucket of sand from the beach, you know, if that amount of sand gets deposited, you know, maybe practical people aren't gonna bother to call that a violation, but literally the way it's written, that would be a violation. So we're gonna cease and desist and shut down the whole job for something that's really quite de minimis. And then the second point is, and I don't mind working on the language, but the second point is, again, the one of repetition or redundancy, maybe not inconsistency, but, you know, this is gonna be closely monitored by both the stormwater management permit with DPW and, again, the order of conditions. So there's really not much to worry about. So, again, I'm not saying to strike it, although I think the last comment I made would support striking it.
What
but-
if you added a sentence that said, use your language, take out the language that's in there, but then you had a sentence that said, if the remedy isn't implemented within a week of notification, then there's a cease and desist.
I mean, that, you know, that's probably okay. Again, I think it, you know, that's more practical, that's the
Okay.
main concern.
Is that,
I
Yep.
mean, does that mean that any off-site erosion could continue for a week? I mean, was that part of the concern? That it would just,
Well, as I said, given the
Yeah.
site, I was worried about,
yeah.
you know, either impact on the MBTA tracks, which is a problem.
I'm just
or
trying to come to a
No,
compromise.
I know, I'm
you know?
just asking a question.
But the answer, I think, is yes.
Okay.
If they didn't do it within a week,
Yeah.
then they'd be shut down.
But, yeah, that could last for a week. The problem could continue for a week before they were shut down, yeah.
Right, but the fact that there's a possible shutdown is another factor aside from whatever, you know, whatever stick under the order of conditions exists.
That was
So
my
the-
thought, was to give them some incentive to move quickly.
Yeah,
Yeah.
exactly.
Page 11, number 28, I had just put in that, you know, they were allowed to have one sign, they want to have two. You know, that's up to you folks, where the signs are and what they look like. I don't know what your normal practice in something like that, but I don't have a problem with
I
that.
don't think
having
we
two
have
signs.
I don't think we have a normal practice. Two signs would be fine with me, I don't really.
Yeah.
Well, there's a sign review committee, I believe, which we have a signed bylaw.
Is that on the list of Peter's waivers? I didn't know that. I saw
Don't know, it may not be, because we usually deal with it by some condition, but, I mean, well,
But I don't have a problem with saying that.
I mean, I don't think,
Is the
you're
bylaw
going to
allowed
have, you're going to have to comply with the signed bylaw as it is anyway, so I don't care if it's one sign or two signs, it's just
Yeah.
it's
More
going
than
to have to
two.
comply with the bylaw.
okay.
And it is going to be the building commissioner that'll have
Right.
an
Yep.
initial review
Right.
of it anyway, so.
So,
Yeah.
that's fine.
On 29, I had put in language in here about the applicant providing a blasting or drilling plan, because there had been testimony presented at the hearings that talked about ledge and the removal of ledge for the construction of the parking garage. The applicant proposes to add, take out the word applicant, and only if the construction entails, I believe that was supposed to be that word,
Right.
blasting or drilling, they'll provide that plan. Well, if you didn't need to do blasting or drilling,
I mean, it seems to
Yeah, I
me
mean, the word,
that's-
I admit that those words, it doesn't really matter whichever way it winds up, because obviously if there is none, then we don't
you're
have
not
to
gonna do
submit
it,
one,
right,
so
yeah.
maybe a brain cramp when I looked at that.
Then, you know, prior to the issuance of the certificates of occupancy, they're supposed to be submitting an as-built plan signed by a registered professional engineer that shows all the construction that's gonna be submitted to the building commissioner. And then, supporting letters that indicate that everything's been built the way it's supposed to be built. The general provisions are just the usual ones, that the inspections are gonna be, you know, the permit's binding on successors of assessors and assigns. You know, any part that's held, you know, invalid isn't gonna invalidate the entire decision. You get to retain jurisdiction, you send the copies, you know, all that sort of thing. Then, let's see, on the last page, on page 12, I had added a clause about any default or violation of the conditions that wasn't cured within 30 days. The town could, you know, seek to cure that, either have the applicant cure the default, or, you know, bring an action to compel compliance, and the applicant's attorney would like to have that stricken.
And the simple reason is there are enforcement provisions, again, in the CMR, there are enforcement provisions in 40B that don't really take away, it doesn't diminish the powers of the zoning enforcement officer or the board to enforce a decision. It just seems to be getting a bit overly detailed, talking about mandamus and particular time period, and, you know, including, you know, having access to books and records and inspect things, which is so open-ended, it's like, I honestly was confused by it. You know, you don't necessarily have to have access to records of ours. If there's an enforcement and, you know, it gets into discovery, so be it. But to say, well, we're in violation of something, and then you say, it almost sounds like, you know, Big Brother. Okay, you're in violation, now we're coming in, open up your books and give us everything, which it's just way open-ended. So, again, I'm not trying to get out of any responsibility, but you're well protected by the enforcement provisions under 40B and general, you know, general zoning law.
What if we just had the last sentence?
That's what I was thinking,
If you what?
the last
The last
sentence.
sentence. The other is all,
Yeah, if you just, if there
Saying
is,
that
if there
things
is,
that you
if
can
there
do
is
anyway.
enforcement, that we pay for it if, yeah.
Yeah,
As long as you add that if we prevail, the town pays.
aha. That's not enforceable,
I say
there's
that
no
with a smile, 'cause I
appropriation.
don't, what?
There's no appropriation for it, you can't,
Yeah,
indemnification for which there is no appropriation, those are
yeah, as a
non-enforceable.
municipal law, that rings a bell. So that's fine.
Question out of curiosity, the CMR regulations, are they different from 30 days, or are they 30 days, or do you know?
No, it doesn't, I don't think it specifies a time
I don't-
period.
Yeah.
Or it doesn't?
No.
I think if we have that last sentence, that's all.
Yeah, no,
we
I
have.
was just curious.
Yeah, that's fine.
That's fine. And then the list of waivers is supposed to be on page 14. And I don't know, Peter, I didn't see in your draft that you had added that.
Well, no, I mean, you know, we had discussed them briefly in the course of the hearings. It's what we requested, is still what we're requesting.
Okay,
You know, the only,
So that list is in the application, isn't it? The
Right.
original, you have the original
I do.
application? List whatever they listed there, we can do more,
just
do no
didn't know
more.
whether, oh, yeah, I got it. Tab 4. So on the waivers, the applicant has requested waivers from otherwise applicable building permit and water and sewer connection fees for the affordable units only. It's on page 1, behind tab 4. I think that's the only,
That's the only questionable one? I mean,
well, I think the ones, I mean, the use regulations, you know, that's kind of, you know, the earth material removal and deposit of fill. I don't know really why do you need a waiver of that requirement, Peter? On the earth removal?
I didn't bring the whole zoning bylaw, or at least I don't think I do, but I think it's susceptible of interpretation that, you know, for any earth removal, you know, you need I'm not sure if it was from selectmen or from the zoning board, but there's some type of permit that's supposed to be required.
Yeah, so you're asking for the waiver of the earth removal permit
Right, well, yeah,
requirement?
The list.
That was dealt with in one of the memos, I think. Wasn't it? You also had a question on the conservation commission.
Since we talked about that, I don't remember why we asked them that. It was weird.
Yeah.
Have you had a chance to go through these, Kathleen?
I got that.
The waivers?
Yeah.
No, because I was wondering if Peter was gonna send me a different list or updated list, but, I will. Because you're gonna have to vote those waivers.
Right.
Right.
I mean, the dimensional requirements, the height requirements, the area, the parking regulations, we've covered those by conditions that are in the permit. But the earth removal, the only thing that I've asked for was about the removal of the ledge and the truck trips that the building commissioner will be reviewing. I don't know whether there's something else in there that,
For Roman numeral 4A. We're looking it up. Roman numeral 4A, 4, section 3.
It's all in section 3.
Said it was potentially circular.
There you go.
I'm looking.
So what it says is somewhat lengthy, so I won't read the whole thing, but Roman numeral 4A, the removal of loam, soil, clay, sand, gravel, stone, or other earth material from any land in the town of Milton is hereby prohibited, except as may be authorized by a permit issued by the board, so you are issuing a permit, and except as such removal is permitted by subsection 5, so it's pretty broad. 5 says, section 5 says,
Buy it.
I went by it. There. The provisions of section 4 shall be deemed not to prohibit the removal of earth material as may be necessary for the purpose of constructing foundations for buildings or for other allowable construction for which building permits have been issued, or for the purpose of constructing ways, or for the purpose of constructing water. So it may be susceptible of interpretation that if we're removing it related to our building permit, maybe it doesn't apply. I just wasn't sure exactly how it's interpreted, and so I think that's the part that we actually did discuss at one of the hearings.
We did.
If you're comfortable that 5 means we're okay to remove earth and fill, because we're doing it in conjunction, for the project for which we have a building permit, then I would acknowledge then it's not a necessary waiver.
That's how I read it.
yeah.
That's how we've interpreted it
Yeah.
in the past.
We have.
Yep, okay, so one less thing, that's fine.
Okay. All right.
The only other one that has sort of been the subject of some discussion in the past is the local wetland bylaw waiver.
But I thought we had a letter from council saying that he didn't think that they needed one.
No, that's not at all, it's just the opposite. What we said that the concern of the board is the bylaw, the local bylaw, more stringent than the DEP regulations, provisions on wetlands that we naturally have to comply with. And my memo dated November 20th, 2014, went through a very point-by-point comparison to which there's been no refutation. And I said, so this should satisfy you that by granting the waiver, which is procedural, saying we don't need to go to the Concom under the local, you're not exposing any harm or risk to the town. So I still respectfully submit we we want the waiver, it to me doesn't make sense to have yet another forum and another, admittedly, possibility for, for some contentiousness. It's clear that your bylaw isn't more stringent, but, we think it should be dealt with purely under the state as is typical of 40B in such a circumstance. If there was a substantive provision which we said, no, we can't comply. So, I mean, there were a couple of things, if you were worried that we were trying to get a carte blanche, there are a couple of things, and quite honestly, I think I did spell out, if you want to, after tonight, as you further draft the waiver, either the waiver or a condition, there are a couple of standards that I said, yeah, we'll comply. I think it was erosion, siltation prevention, catch basins, oil separators. There are a few things, I think it's on page 4 of, again, my November 20th, 2014 memo.
I recall that.
Yeah,
Okay.
so
So
again.
you would address that by conditions,
Yeah,
but otherwise grant
Then
the
you
waiver
waiver
of
it,
the
right.
bylaw. I mean, that makes
Yeah.
sense to me.
yeah.
I think that's sort of the solution that we had kind of,
No, that's what typically happens.
we hadn't voted on it, but I
Right.
think that's the direction
That's
we
where we
headed.
were heading, because I remember that,
Mm-hmm.
that letter and that discussion.
Yeah,
Okay.
Okay.
I think that's it.
Yeah, I mean, I assume you're denying the requested waiver of building and permit and water sewer connection fees for the affordable units.
I don't see any reason to grant that waiver, frankly.
No, me neither.
It's a good reach by Peter, but I don't see it.
we always reach, and sometimes we grasp.
All right, so from a process
Okay.
standpoint, you're going to take a hand at trying
I'm
to,
gonna take a hand.
Shall we
Cap-
take,
go ahead.
sorry for interrupting, I did it. 2-minute recess to talk about that one other one? I think there's two we
The
need to
Concom?
quickly come back to.
There were two we said we were going
Yeah.
to come back to.
Okay, that's fine.
Yeah, thanks.
Let's do that.
We won't be long.
Take as long as you need. We are in recess.
Trying to meet your concern, but simplify it. We'd rather, this is the one about when is the LSP retained and that inspection done. So we'd rather not get into the, possible conflict with the Conservation Commission and all of that. What I think will do it, and it's simpler, is just say that after the demolition of the building, but before obtaining the building permit, the applicant shall perform a 21E report, and then, the rest of the language is fine.
What, after demolition of the building, but before?
Before obtaining a building
Well,
permit.
wouldn't you have it before you remove the tanks?
Yeah, that's what I thought we were talking about.
Not the building permit.
Well, I don't,
You have to do it before the tanks anyway.
You have to do it then.
You got,
yeah,
That's
so,
fine, yeah, that's fine.
yeah, I get, yeah, but that, distinguishing the building from the actual tanks underground, that's fine. So after demolition of the building, but before
Removal
removing
of
the
the
tanks.
underground
Yeah.
tanks.
Then the applicant, you'll,
Shall,
you
right,
get rid of
then-
the stuff about Concom and all
Yeah,
that.
yeah, right,
Just say
and-
the applicant shall engage. Yeah, that will
Right.
do it.
Okay?
So we're leaving in about Concom or?
No, no,
Taking it
no,
out.
no, we're just,
60 days is out, there's a specific
60
time
days,
frame
right.
for it to be done, which is the important
so it'll
time
start to,
period.
it'll start to read, after demolition of the building, but before removal of the tanks, the applicant shall engage the services of a licensed site professional who will do a 21E report. No building permit's gonna be issued until the report indicates that everything's fine, or the applicant has removed and mitigated such oil or hazardous materials.
Yep, agreed.
Okay?
Yep.
Great.
And then the only other one was the business about the time limit on construction, which, you know, Steve's even more nervous after I told him I couldn't give a good zoning opinion and lenders might get spooked, and so, you know, I don't think I'm being unreasonable to try to be firm on that, because again, you have adequate protection in terms of what the lapse provisions are, and, you know, the pragmatics of this project, like I said, not being phased, and then thirdly, the fact that, you know, again, if the building construction is started and for some reason it sits there for, I believe it's, either it's somewhat, I can't remember if it's a 6-month period or a year, but somewhat within the judgment of the building inspector, you know, at some point, a building permit's gonna lapse, you know, you just can't sit out there anyway, so it's kind of self-controlling anyway. So I just have a real problem with my position and my client's position with the lenders if it stays in there.
What paragraph is that? I
It's,
forgot.
it's
Uh,
paragraph
25,
20,
page 10.
25 on
was
page
crossed out,
10.
Construction and
But I would point out to the board that actually, I did say that on page 12, in paragraph 38, that under normal circumstances, as Peter says, this comprehensive permit expires if you don't start construction within 3 years. I have put in language, and Peter hasn't changed it, which says that for the purposes of this paragraph only, commencement of construction is defined as the demolition of the building.
Mhm.
So that 3 years is gonna start to run from when they take the building down,
Okay.
not from when they start to build a new construction. So I think that does give us, you know, sort of a shorter time period, than they might otherwise have.
Okay.
Because as I said, it's gonna start from demolition.
So then are you willing to take out
So I'd be
paragraph
willing to
25?
Take out 25?
Okay,
25.
that's fine. I mean, we don't want to do anything either intentionally or inadvertently that's going to cause you to run afoul of any financing stuff, so.
Yeah, exactly. That's
not
why,
our-
you know,
That's not our intent.
No, understood, and I appreciate it.
And I think the point that, you know, it probably works more appropriately with a phased project than it
Yep.
does with a
Exactly,
single.
exactly. No, been there, done that, and,
Yeah.
you know, yeah. Okay.
All right, so
What's next?
you're gonna
I'm gonna-
do a draft, we'll all have a chance to look at it.
Whatever, yes.
Everyone will look at it, and then we'll come back and we'll have final discussion about the draft, and then we'll vote on a final form of decision.
Right.
So it's just a matter of picking a date, and you had given us some options.
This is the only thing that's on the calendar right now, on the town website.
Those are the only dates that are currently,
That are currently taken.
so that means we can't have those dates?
No, we can, depends on the loan.
Is it better for us to have them on those dates because things are otherwise going? Is that
No,
your point?
no, we can do it anytime. I was just looking at this to see if you picked out a date, and then this one wasn't available.
Mm-hmm.
We'd love to celebrate St. Patrick's Day with you.
What's a reasonable period of time, Kathleen? I'd like to get this done.
I'm gonna do this while I remember what it was, so,
Let me see this.
Don't worry, I'll
quite
correct you.
honestly.
If you turn it on the other way, you can.
Well, I
see
can
what
read my
loan you're in.
handwriting.
I don't know if we necessarily need to
Okay,
but-
we don't need a big room. You don't like Tuesdays, right? How about March 18th?
I'm here for the hearing on H&W.
Yeah.
March 18th?
Well, I know it's just a meeting,
I'll
but
be
I
away.
have it.
The Randolph
That's
Drive
only a
vote.
couple weeks from.
Right, you're gonna be
Yeah,
away?
I'm away the 12th to the 19th.
Okay.
Are you okay with that, or should? No. On the 18th, I have another zoning board hearing further away.
Somehow I've lost us. Yeah.
12th through the
I'll find it.
19th 's out anyway.
Yeah. And the 24th and the 31st don't work for you, Frank, is that?
Right, those 2 Tuesdays don't work for me because I need to be in Rhode Island. I'm in front of the legislature,
Mm.
both nights.
Wow.
So a Thursday's better for you?
Yeah, Thursday the 26th works for me.
That one doesn't work for me.
And-
How about
and,
the following Tuesday? I think it's like April 2nd.
31st, oh,
How
April,
about, oh, he's away till the
Yeah,
19th.
If we get into April, I have a problem for the first week because I'm having cataract surgery on the 1st, so I'll be out of commission until the middle of the following week.
March 26th?
I am going to be away.
do you want to meet next week?
How about next week?
I can do it next week.
Next week, when?
I have a hearing the 10th.
You know what, I can do the 10th. My problems, my 2 problems with Tuesdays are the last 2 Tuesdays in March, so Tuesday the 10th is okay with me.
It's okay with me, too.
I have one at 7:30.
With Concom the 10th. If they want to do it
What does that
early.
mean?
Can't be two places at the same time? Unless we did it.
Why don't we do it, what if we did it at 7:30, 7 o'clock or 6:30?
Yeah.
6:30 on the 10th?
That's fine with me.
That's good,
Is
because
that
we
all right?
have to be, we have our
No,
next
with me,
Concom hearing.
yeah.
at
Is that all right?
6:30 on March 10th?
Yeah, I don't
Great.
expect it to be very long.
Yeah, I would agree.
Do you guys want to do it in the John Cronin?
I can only do it here. Oh, no, just kidding.
Would that work
I
for
want the
everybody?
biggest room that's being used that night. That's important to me.
Does that make you feel better?
Wherever you want us to go, we'll go.
I would love to have the John Cronin, because I'm meeting in there
Wonderful.
afterwards.
I just don't want Leonard to have a bigger room than me. That's key.
And he will be on that, he'll be in the same room that night.
All right, whatever room you put us in, 6:30 March 10th, we'll be there.
This building, but some different room?
Yes.
Upstairs.
Second floor?
Okay.
We have a selectmen's meeting scheduled, tentatively scheduled for 6 o'clock that night
Oh, you do?
in the corner room.
Okay, why don't we do it right down here at 6:30 then?
It's a little bit up in the air because the Concom meeting at the moment,
Okay.
it's the tentative plan today.
Well, we'll do it down here at 6:30 then.
That's fine. Blue room, 6:30.
That's March 10th.
Okay. Thank you all.
Great, thank you very much.